Okay. All right. Case number 22-190347. This is Progressive Marathon Insurance Company versus Ganesha Gunter. The matter is before the court set on for a status and scheduling conference. The court is in receipt of the defendant's answer. The matter is joined, and I set it for status conference. Let me have your appearance for Progressive Marathon.
Good morning, Your Honor. Jennifer Dillow, P69855, appearing on behalf of the plaintiff.
Thank you, Ms. Dillow, and good morning to you. Do I have Ganesha Gunter on this Zoom? Say something if you're here, please.
Yes, sir. I'm here.
All right. Good morning to you, ma'am. So I've looked at the answer to the complaint as well as the complaint in this matter. The next step would be to set up a schedule regarding this particular case. Have the parties, Madam Counsel, Ms. Dillow, have you had an opportunity to talk about this to see whether or not there might be room for a resolution? I know that the claim indicates some $2,300. Looks like this is a subrogation claim where there was an accident and a vehicle was damaged. That vehicle was repaired, and you're seeking to recover the cost of those repairs. Is that about the size of Ms. Dillow?
Yes, Your Honor. As of today's date, we have not had discussion regarding resolution.
All right, Ms. Gunter, are you interested in having a discussion to see whether or not you can reach some type of agreement to get this resolved?
Yes.
All right. So let's take a moment to do that, and then you'll come back into the courtroom. And if you're not able to reach an agreement, I'll put it in the process and set up a schedule. But see if you could talk about this and see if there's a way to bring this together. Given the numbers, fortunately, this is not a $10,000 or $20,000 case. Maybe you can reach some type of resolution. Here's your notification to the breakout room, Ms. Gunter, and Madam Counsel, I'm sending the same to you for breakout room #1 as soon as I can find you. Found you there.
Okay.
And I'll see you guys back. Come back in the courtroom afterward, and we'll go forward from there. Right. So go ahead, Ms. Gunter, and click in. All right, the court now calls case number 21-173168. This is credit acceptance versus Tyrone Hagan. The matter is before the court. Set this up for a hearing after the reinstatement of a matter that had been previously dismissed. Your appearance at this time for credit acceptance, please. Do I have Tyrone Hagan on this Zoom? Last name Haggen. All right. I'll come back and recall this matter. It looks like there's an application for entry of default. The court set it on for hearing. Nobody has responded. I'll come back to it momentarily. The court now looks to case number 22-182312. This is ZMC Pharmacy LLC versus Suburban Mobility Authority for Regional Transportation, SMART. The matter is before the court for a pretrial conference date. All right, your appearance for ZMC, please.
Good morning, Your Honor. John Kotang on behalf of ZMC Pharmacy.
All right, your P number, if you will, counsel, for the record, please.
Yes, Your Honor. PA1641.
All right, thank you, counsel, and good morning to you, sir. All right, for SMART, your appearance at this time, please.
Good morning, Your Honor. Joseph Giacalone, P85482, appearing on behalf of defendant SMART.
All right, thank you, Mr. Giacalone. Good morning to you as well, sir. Looks like the last thing that came up here was a stipulated order compelling answers to set of interrogatories. Somebody go ahead now and update me. What else is outstanding? Are you discussing resolution, Mr. Giacalone, if you will?
Yes, Your Honor. That order was entered, and since then we have received plaintiff's answers to interrogatories. The previous pretrial settlement conference, I want to say that was in mid-October, we set this as the cut date for all discovery in this case. I had a chance to talk to plaintiff's attorney prior to the conference today, but that was the first time that I had gotten a settlement demand. So I have to take that back to my client to discuss that with them. Other than that, Your Honor, it appears discovery is closed in this matter, and we're working on trying to reach a settlement, or if the court would want us to go to an alternative dispute resolution, whether facilitation or case evaluation, defendant would be open to that.
All right, counsel, your thoughts, anything you wish to chime in on? Counsel?
I would just mirror counsel's request for either case evaluation or facilitation.
All right, very well. So you got an offer on the table that's up for consideration when both lawyers are saying something about alternative resolution. It seems that that's probably the direction things go. So of course, evaluation is one thing, facilitation is another. My first inclination would be to set it up on a mediation schedule and get that taken care of. That's less expensive. But obviously, I would order facilitation that both of you are shouting for that. That's a little bit more expensive, obviously.
Your Honor, if I may, is there a chance the court could schedule us for about 45 days out to get around the holiday season and then come back with another pretrial status conference before going to a final status conference or getting a trial date?
Yeah, I could certainly put it over after the holidays, probably late January. I'd like to take another look at it at that time. As long as you feel that maybe some progress would be made, and you try to drill down on the numbers a little bit. If there is some effort in that regard, then it's worth taking a look at it before any additional process. So let me go ahead and do it that way. It makes sense. I'll go ahead and set it for, let's do it the 23rd of January, 123. 123. That's going to be at 9:30 a.m. 123, 9:30 a.m. I'm going to set that I'm going to set that as a final pre-trial conference, and then we'll take a look at where everything is, see if we need to set it on a trial or some other alternative type of scenario. So 1/23/23 at 9:30 a.m. You will get a new notice in that regard. I'll be at a different Zoom number as well, so make sure that you give attention to the notice that you receive. All right. I wish the two of you well. Good day to you.
Thank you, Your Honor.
Thank you, Your Honor. Good day.
All right, the court now looks to 21-147080. This is Jefferson Capital Systems versus Terrell O'Neill. The matters before the court on the following objections to a writ of garnishment. That writ of garnishment is in regard to the third-party withholding unit of the Michigan Department of Treasury. This is in relationship to a judgment that was entered on the 2nd of July 2021. That judgment on entry was for the amount of $6,098.05. Your appearance for Jefferson Capital, please.
Good morning, Your Honor. Brian Truba appearing on behalf of the plaintiff Jefferson Capital Systems. My P number 61752.
Thank you, counsel, and good morning to you, sir. I'm looking now for Mr. Terrell O'Neill. Mr. O'Neill, if you're on this Zoom, go ahead and say something at this time, sir.
Your Honor, she's here. She's the 586-420-0980 number.
All right. Ms. O'Neill, say something to me. I know that you're there. If you can hear me.
Your Honor, I think before you appeared, she was having trouble muting and unmuting herself earlier, so she may not know how to unmute herself.
All right, thank you. Ms. O'Neill, if you hit *6 on your device, that should unmute you, *6. Also, if you see a microphone on your device, you tap the microphone, that would unmute you. But *6 should do it, ma'am. So you guys didn't get a chance to talk about this at all, Mr. Tuber, is that correct, sir?
Your Honor, we talked about the substance of our objection last year, but not today and not recently.
All right. So Ms. O'Neill, I'm going to come back to you in just a couple minutes. So try and find your way to unmute yourself. If necessary, ma'am, just hang up and call back in. Just do that right away. Just hang up and dial back in just the way you came in previously, and you'll be unmuted that way. You either hit *6, or if you're having trouble, just go ahead and hang up and dial right back in. And Mr. Tuba, I'm not seeing her in the chat, but if you could chat her, I don't know why I'm not picking her up here.
Judge, I don't mind if you pass on this. You got a couple of attorneys waiting.
Yeah, that's what I'm, and
Okay.
that's what I'm intending to do. I'm trying to avoid this, I was taking more time with you because I'm trying to avoid these folks that have come to me about 50 times now, but like, I guess I have to, I'm being facetious, I guess I have to come to them now.
Okay, fair enough, Your Honor.
All right, so I'll come right back to you. All right, this is case number 18-241991 GC. This is Jones O&E versus Reina El Hadi et al. The matter is before the court on a date that is set for trial. All right. Your appearance for Jones O&E and at this time, please.
Thank you, Your Honor. David Palmieri appearing for Mr. Onwenu, P26796.
All right, thank you, counsel.
Hello?
Good morning to you. Good to see you again. Just one moment, ma'am. I'm coming to you. Stay right there. I'm coming right.
Good morning, Your Honor. Michael Elkins, P29725, appearing on behalf of defendants.
And Mr. Elkins, your P number, if you will, for the record, sir.
P29725.
All right, thank you, counsel. Good morning. Good morning to you. And I do see that Mr. Owenu is on the Zoom as well. Good morning to you, sir. All right, so somebody tell me, I know that there was some thought that there was progress in these times of supply chain.
We're at the position right now, Your Honor. We're waiting for Mr. Owenu's agent to contact our agent at the Tincan Island in Nigeria so they can open the shipping container and they can examine the vehicle to start with, physically examine it. But we have had no contact from Mr. Owenu.
Counsel?
Your Honor, it's my understanding that the parties are even today going to make contact with each other in Nigeria through their agents to make arrangements for us to actually, for the first time in years, see and inspect, perhaps take possession of this car, or at least set the parameters for taking possession of the car. This will answer a huge number of questions that the court would otherwise have if we proceeded to trial. In addition, and quite secondarily, I was ordered into a hearing in probate court in Oakland County, which is where I am sitting in the hallway right now at this exact same time. So I do have a scheduling conflict, but you ordered us to your court long before that judge ordered me here. But it does make sense to me, although I've been the one pressing for some resolution here, that if we did not proceed to trial today, one last, well, I swear it'll be the last adjournment, and we could answer the court's questions about what's the car worth, what shape is it in, what's its value now, what was its value when it was first shipped, and so forth. Otherwise, those will be mysteries at trial, and the court will be asked to make inferences. It's a much more difficult case unless we can see the car. We're arranging that, as I say, tomorrow.
All right, so, yeah, that makes sense. Obviously, being able to see the subject matter of the dispute and making some assessments as to what the conditions are, et cetera, is critically important. I'm wondering if, setting this for review, next week, and having the parties back to see where you are at least, before setting another trial date. Will that give you enough time if I set it over for next?
I understand that plaintiff wants to have the vehicle physically inspected by his mechanic, or some mechanic. They'll need time to do that, Your Honor.
We're being told, Your Honor, that the time for actual delivery of the vehicle, we can open the shipping container, we can take a look at the condition of the car, but to have it mechanically inspected by professionals, we have to have possession, and to get possession is going to take about a week as they unload the container and move the contents across the island and deliver them to the agents who are entitled to have them. So that's all I know about it. And
That's my understanding also, Your Honor.
And I know that we're approaching the holiday seasons. What if I brought it back January 5th to take a look? I want to review, and make sure that this is moving along and see where things are.
that strikes the plaintiff as perfect.
I have no objection. Let me just check make sure that my schedule is not a problem. January 5th, what time, Your Honor?
Thinking 10 o'clock a.m.
Should be fine, Your Honor. Thank you.
All right, so I'm gonna go ahead and that will be a trial date. That's a court order review date for January 5, 2023 at 10 o'clock a.m. And I'll take a look at it and hear positions as to what has been observed up to that point. And then the court makes some decisions as to the nature of any hearing that might be necessary. Might be more in the nature of evidentiary hearing than a trial. But if it has to be a trial, we'll do that as well. And we'll try to get that on as quickly as we can.
Thank you, Your Honor.
Thank you very much, Judge.
And a good holiday season to you, Your Honor.
Likewise to everybody. I'll see you on January 5 at 10 o'clock.
Thank you.
Very much so. Thank you, Your Honor.
Good day to you. Let me come to Ms. Dillow. I'm coming to you in just a moment. Mr. Truber, are you still there, sir?
I am, Your Honor.
All right, and I believe that Ms. O'Neill is present also. We're on the record in the suffix 7080 Jefferson Capital versus Terrell O'Neill regarding objections to a writ of garnishment. And Mr. Truba has ended his appearance with regard to this matter. Ms. O'Neill, you there, ma'am?
Yes, I am.
All right. So I noticed on your objections to the writ of garnishment that you indicated this bill has been paid and that was your basis for objecting to the writ of garnishment. Are you saying that the $6,098.05 judgment has been paid off?
No, Your Honor, this bill is over 30 years old. The original bill was 2,000. I have the exact amount. The point that I'm sorry.
The only thing that I can address is the judgment going forward. So the judgment was entered in July of 2021. And if you wish to try and get that judgment set aside, you have to file a different type of motion to do that. There is a judgment in
Okay.
place, and the plaintiff has the right to go after the amounts that's claimed in that judgment. If you believe for some reason that that judgment is not properly entered, then you'd have to file a motion, like a motion to set it aside, or you'd have to attack the judgment. Right now, the only
Okay.
thing important is the enforcement of that judgment. So if you're gonna attack it, you gotta go after trying to see if you can get that judgment set aside. But as long as that's in place, the plaintiff can file writs of garnishment, like against bank accounts, tax returns, and also can file garnishments against wages as well. As long as that judgment is in place, man. You understand?
Yes, Your Honor, I have a mental disability, and at the time that the court case went forward, they did not do due process by contacting me, and I received I was served, and that's how I knew about it. And immediately I contacted them and faxed over the paperwork showing that this was paid by the state of Michigan. This is a 30-year-old debt. I was on assistance at the time. And at that time, I also was hired in at Detroit News. So my involvement with the state was limited at that time, even though they paid the bill. But once they closed my case, it was impossible for me to go back and try to get some kind of validation from DTE or the state that the bill was paid, although DTE told me it was paid. And I do have paperwork from the state stating that it was paid, but they never did due process. Once I submitted to them it was paid, they did not validate the account. They never communicated with me at all. I was just served. And the bill is not even correct. This bill is 30 years old. It's got $4,000 worth of interest on it. Even the limitation on this should be over at this point. But I hear what you're saying, Your Honor, and I appreciate your guidance.
Now, once you received the notice that you were being sued, then what you were required to do was to file something in writing with the court, some type of answer complaint.
Your Honor, I'm aware that I was under a representative at the time. Social Security had someone caring for my affairs. My mental illness, I have good times and I have bad times. And on them bad times, I'm not capable of being responsible for certain things, Your Honor. So this is why it's such a delay, and I apologize.
Not a problem, ma'am. Were you under a court-ordered conservator, or I should say a guardian or anything at the time that this case started?
Only thing I was under was Social Security because of the nature of my disability.
What I'm trying to find
Yeah.
out is whether or not you are, I'm trying to find out whether or not you were a protected person, like whether there was a guardian that was appointed to you or something like that.
Not by the court, Your Honor.
Oh,
No,
okay.
not by the court, just by my Social Security administration.
Gotcha, understand. All right, well, Mr. Tucker, anything you would say?
I'm sorry.
Yeah, I'm sorry. I'm sorry, Judge. I didn't hear that something fell and.
Mr. Truba, anything that you have to say? That's what I was asking.
No, Your Honor, we'll just rely upon our response in this. As the court, as the defendant indicated, she admitted the judgment's not paid.
No, I'm admitting that it is paid. It's paid by the state of Michigan through DHS.
Well, it's different what you're saying. What you're saying is that before this ever came to court, that it was paid off. I can't take that.
Yes.
You have to file the proper paperwork to try to get that brought before the court. But the judgment,
Okay.
The judgment that was entered in July of 2021, that has not been paid. That's what counsel was saying. Because there is a judgment in place, the plaintiff does have the right to go forward with the filing of a writ for execution in this matter and writ of garnishment. Therefore, the objections hearing are invalid at this time. Any funds withheld will be released to the plaintiff under this garnishment. And again, Ms. O'Neill, you received some direction as to the steps that you can take. And I wish you well in that regard.
Your Honor, will they stay this until I file? It sounds like they can move forward, and if I'm trying to move forward to rectify this situation, I mean, it's going to be kind of hard in hindsight to put whatever back.
Well, what happens is,
I feel like if I'm coming before the court and I'm giving you an explanation as to what occurred, seem like there should be some kind of stay or some time frame given to me to apply to the court to have it set aside or whatever motion I need to. I'm at the courthouse right now.
well, whatever
I
motion
actually thought,
yeah, whatever motion you file will be taken into consideration. But what happens is that if because there is a judgment in place, the writ is allowed to go forward because there is a judgment. Now, if you get that judgment set aside, any money that was collected by the plaintiff, they'll be required to refund that money to you if the judgment is set aside. If the judgment is not set aside, then of course they will be able to keep the funds. So because there is a judgment in place, they're allowed to garnish and take funds that might be available. Now, you were telling me that you receive Social Security. Do you receive any other kind of payment?
no, I do not, Your Honor.
Do you receive a tax return from the state of Michigan? Do you receive any money from the state of Michigan?
I don't file taxes, Your Honor, for my Social Security.
Well, the reason I ask that is because this is likely a moot point. What they filed is they filed a garnishment against the state of Michigan, meaning that if you are receiving a tax return, then they would be entitled to take the money from the Michigan state tax return. If you don't file a tax return, they can't receive anything. Now, the other area that this can come up is if you play the lottery and you win some money through the state, then of course they could garnish the money from the lottery to pay on this judgment. You
Yes.
understand?
Yes, Your Honor. What about bank accounts?
Well, they could garnish your bank accounts, but that's not before me right now. And if in your bank
Okay.
account, if all you have in your bank account is money from Social Security, then that money is not allowed to be garnished. They can't take that. Can't take Social Security,
Okay.
right? All right.
Yes,
ma'am.
Your Honor.
All right. I wish you well, man. Good day to you.
Thank you. Thank you, Your Honor, for your time. Appreciate you, sir.
And likewise to you. All the best to you, man. Happy holidays. Thank you, Council. Good
Thank
day to
you.
Thank you, Your Honor. Have a good morning.
You too.
Thank you, Madam Council, for your patience, Ms. Dillo. And I believe that you're on the progressive matter. Is that correct, ma'am?
Yes, Your Honor.
Right. We're back on the record regarding 0347 Progressive versus Kanisha Gunter. All right, and both parties went into the council, and Ms. Gunter went into a breakout room just to kind of see if there was room to get this resolved in a kind of way. Why don't you go ahead, Ms. Dillo, and update, please.
Yes, Your Honor. The parties did have an opportunity to discuss the matter. We do not have a resolution today. The defendant disputes both liability and the damages claimed. So at this point in time, plaintiff would request a scheduling order opening discovery for at least 60 days.
All right. Ms. Gunter, you understand that's about the size of things to your best estimation, ma'am?
I do.
You broke up a lot. What did you say, Ms. Gunter?
Yes, I understand.
All right, very well. So what I'm going to go ahead and do, ma'am, is I am going to set this up on a scheduling order. And with that scheduling order, it's going to give you a next court date. That court date is going to be for a pretrial, at which time the court will review where the parties are, whether or not there's been completion of discovery, exchange of information. So the next action date in this matter is going to be February 13th. That's going to be 2/13/23. Discovery is allowed through that date, and that will also be the next date of hearing. The hearing on that date will take place at 9 o'clock. I'll strike that 9:30 at 9:30 a.m. So 2/13/23 at 9:30 a.m. will be the pretrial date. You will get a document from me in the mail that's called a scheduling order. And that document will allow for the parties to exchange information And it will set the next court date and other information that the parties will know which way to proceed regarding this matter with the upcoming court date. So I wish you well. You'll receive a copy of that written document from me in the mail in the next few days.
Thank you.
Thank you.
The report now is recalling 3168. Looks like in that matter, Credit Acceptance Corporation versus Tyrone Hagan. The court did set the matter on for hearing on today's date. Neither party has appeared. The matter was dismissed previously, but it was reinstated by the court on an application for reinstatement. And then there was a application for default where the plaintiff has not appeared regarding this matter. The application for default will be denied. So ordered. Right.